Hello, good morning everybody, and thank you all for attending our employment legislation update and overview webinar this morning. My name is Laura Murphy, I'm the HR manager here at Bright Contracts. Today I'm joined by my colleague Jennie Hussey, who has been working with us here at Thesaurus Software for the last 20 years, so she definitely knows a thing or two about employment law and payroll as well. Okay. So the aim of today's webinar is to, I suppose, to peel back all those layers of employment legislation and to put them into bite-sized chunks for you to give you some key points of action as to hopefully how you can stay ahead and keep your business protected as you go forward. Just to kind of give a quick agenda, what we'll do is we leave some slides here in a presentation, and Jennie and I are going to go back and forth. It's easier for us just to kind of take questions in at the end of that, and then we have a short solution, a little demo with some solutions of the issues that we've raised, and we'll go through that at the end as well. But please do, if you have questions as we go through, do ask them, and then we'll get to them at the end. So we'll get going. Hopefully you've managed to grab yourself a cup of tea and are comfortable, and we'll get going. So to kick start, I just want to give you two figures. The first figure is the number 30 plus, and you're probably wondering, what does this mean? Well, this is the number of pieces of employment legislation that are in operation in Ireland today. So you've got over 30 pieces of employment legislation that are out there. The second figure that I want to give you is 3,300,000. What's this figure? This figure is the total amount that was awarded by employment tribunals in 2015 in unfair dismissals cases. So the overall total. The average compensation in per case was roughly about 15,000, 16,000. So quite a significant figure, I think you'll agree. So overall, I think it's fair to say that there is a huge amount of legislation out there, and that B, the cost of getting it wrong can really be quite significant for employers. And the thing with employment law that I always say is that, and it's the catch for small employers, is because it doesn't matter if you have a massive multinational company and you're employing thousands of staff, or if you are a small startup or a small company who's employing 2, 3, 5 employees, some of which might be part-time. The exact same employment legislation will apply to you as it will to the multinational. So it's a bit trickier for a small employer who mightn't have the resources. So some might say an unfair playing field, but we'll hopefully give you some tips today. In truth, when I'm talking to employers, I get the impression that there's a lot of confusion and certain misconceptions out there, particularly among small employers. And I've just put up a kind of a taste of some of the comments that small employers would have said to us over the years, and the type of things that they say is that they only have 1 or 2 employees, and they have a really great relationship with these employees, so they don't really feel they want to worry too much about employment legislation or get too bogged down with that. And I think, Jennie, on the phones particularly, that's something that comes across a lot.
Well, yeah, to be honest with you, we actually get quite a lot of people saying, well, it's a family business. I work with my brother. And all well and good that might be, it's especially difficult to have clear boundaries, especially when family are involved. So really having the contracts and company handbook in place from the beginning will eliminate any issues from occurring in the first place.
Perfect. And I suppose, to a degree, small employers are correct when they say, they don't want to get bogged down in the employment law side of it. And absolutely, I would say don't spend a huge amount of time of it. You've plenty of other things to do, whether it's marketing or finance and running your business as well. But what I would say is, do not totally put your head in the sand regarding employment legislation. Take some time, put a good framework in place, put some building blocks in, educate yourself in key management on a number of certain key aspects of the legislation, and then as your business grows and develops, you can adapt your policy. But you definitely don't want to hinder your business growing because of fear of employment legislation. So we kind of, as I said, we'll break it down in bite-sized chunks today and hopefully give you some tips. But I suppose just to start off, we just kind of look at 2016 on review. What were the key highlights from last year? The first one, the WRC, 1 year on.
Well, the first point we'll look at is the Workplace Relations Commission. The WRC has been in operation for just over a year now, and I'm sure you're all familiar with the work from many of the high-profile cases that's been on the news. They recently published a progress report on the first year in operation, and to be truthful, all in all, the figures are stacking up quite nicely. There's been a significant reduction in waiting times for hearings and a substantial reduction in the backlog of cases, which was a huge issue when it was going through the labour courts previously. So it has been good, if not slightly testing for the first year of the WRC. Another thing in 2016 that came about was the minimum wage. It increased to $9.25 per hour from $9.15 from January 1st of this year. So if you do have current employees on the minimum wage rates, that increase should have been put in place from January of this year. The minimum wage is actually in the news lately. Was there something about Debenhams in the UK not paying their minimum wage there recently?
Yeah, it was in the UK actually. But it's an interesting case, I think, or an example. What they do in the UK is actually the government every so often release lists, and basically what they do is they name and shame employers who are not paying minimum wage. And then Debenhams, for such a big employer, well, they got quite an embarrassment, I suppose. In February, the government released their longest list ever. There were 350 employers on that list, and Debenhams topped the list. In total, Debenhams had underpaid £100,000 to over 11,000 of their workers. So bit of an embarrassment for them. Thankfully, I suppose, well, hopefully it wouldn't happen here, but we don't have the same in Ireland. But I just, on a lighter note, to finish that point, as part of the research when they were doing their naming and shaming, they did some research as to why companies were not paying minimum wage and what excuses, if you like, were given. And I think there was definitely some interesting and imaginative excuses. One of them was a shop who had shop assistants in the store, and they would argue the point that they only paid the employees when there were customers in the store, because they didn't feel the employees were working when there was nobody in the store. So I thought that was a little bit of a more interesting one. But that's just a little aside to break it up, I suppose.
They do well to try to get away with that one over here.
I think so.
The next one then, just on review, was paternity leave. So this was one of the big news stories that came in 2016. So fathers and partners are now entitled to 2 weeks paternity leave with statutory paternity pay. Now the stats shown to date show that the take-up has actually been quite slow, but certainly over the phones we've seen a number of queries coming in relation to it. People asking about how to actually process it through your payroll. Do you have to accept the requests for it? When can it be taken? Really the best answer to that is to have a proper and solid paternity leave policy in place, so that these questions can be easily answered when they do actually come up with your employees.
Yeah, perfect. Just the final thing then from 2016, I suppose, was the contract cleaning ERO. So the ERO is the Employment Regulation Order. Certain industries have these. They're just specific legislation that maybe is a little bit beyond the basic entitlements, such as minimum wage. In November, we saw some changes to the contract cleaning ERO. So again, if you're in this industry, if you're in that realm, it might be just something that you need to be aware of as well. So cracking on then to 2017, what are we looking at this year? What are the key changes? The key word and the buzz phrase this year, if you like, is going to be the gig economy. Particularly over here and in the UK as well, we're seeing that there's a lot of talk on this topic. So the gig economy refers to the whole 0 hours realm, the if-and worker, your atypical worker, your casual worker. And I suppose it's an area where there's been a lot of confusion of late. Currently, there is actually a bill being discussed through the Oireachtas Committee on Jobs, Enterprise and Innovation, and the aim is dealing with this whole area. What the bill is proposing at the moment is that workers who consistently work hours above those hours that are prescribed in their contracts of employment, that they should be entitled to seek revised contracts that accurately reflect their actual working hours. And that said, this bill has not been met as positively as expected, but from a lot of the employment bodies such as IBEC and CIPD, and definitely we would kind of be of the view to be agreeing with IBEC and CIPD on this, because anything that is set out to jeopardise or jeopardize flexibility for a small employer has to really be something seriously considered. And so if as a small employer you're using somebody as and when, because you don't know when your business is going to need somebody and you cannot commit to a full-time permanent contract, then you're going to use these gig workers. So yes, maybe we do need some more of a framework on it, but the bill that's going through at the moment, I'm not sure if that is the correct bill. But at the moment, it's very much a wait and see what happens. But it's the buzzword, as I said, for 2017. The other thing this year that we might see more of is whistleblowing. In 2014, we saw the introduction of the Protected Disclosure Act. So this is an act which offers protection to employees who blow the whistle on any wrongdoing in the workplace, and whether that is financial wrongdoing, discrimination. We didn't see any cases on it, and it kind of came in and was quietly just integrated, I suppose. But the first case came out last year in 2016, and I think that was kind of the floodgates might open. We might see more. Obviously, we're all familiar with the Morris McCabe, and then the Gardaí. But in 2016, we saw the first case in the private sector. So that's the difference there. And we may see more coming in. I suppose, similarly to what Jennie is saying, for a small employer thinking, well, what is this going to affect me? Well, you never know, I suppose. And best is to be prepared, and hopefully you've got all proper practices in place. But again, similar to what Jennie was saying with the paternity leave, just to take some precautionary measures and to put a whistleblowing policy in place. And basically the crux of what your whistleblowing policy will do is it will set out a format that if employees want to blow the whistle, that they have a set format of where they can do it and how they can do it. And so rather than employee blowing the whistle and going straight to the media, which really as an employer is not what you want. You don't want your stories going out in public. You have a set prescribed method where it can be dealt with internally first. So again, hopefully, it's not going to be something that is going to be too much of a concern to you, but as an employer, best probably just take some precautionary measures and put in a whistleblowing policy in place. But I think we may see more of those cases coming up in 2017. So I want to move on now to the workplace inspection. Jennie mentioned the WRC earlier on. So one of them, we're all again familiar with the WRC. They've been in the news of late. They've been kept busy of late. But they do deal in negotiations and they deal in mediation. But another one of their roles is as a main enforcer of employment legislation, is to carry out workplace inspections. This, of course, was previously done by NERA. Maybe some of you are familiar with NERA, but since the WRC came into operation in October 15, they've now taken on that responsibility. So as part of the WRC inspections, they have the power to carry out a workplace inspection, planned or unplanned. Now, generally, when they're carrying them out, the inspection will be carried out as a matter of routine, as a result of a complaint or as part of a focused compliance campaign. So what we've seen or what we're seeing is that they may pick a particular town and they literally work their way down that main street, or they might pick a particular industry where they decide, well, we'll look at hairdressers this month and they'll go for that. You won't know if you get a WRC inspection. You won't know why it happened. They won't say that we're coming here because of a complaint. You'll just have the inspection. So I suppose I deal with a lot of businesses, or Jennie and I both deal with businesses every day of the week, and there's definitely, I don't want to say a denial, but employers feel like, well, it's never going to happen to me. It's not going to come on my doorstep. But unfortunately they do, and they will. So I just want to give you a few little stats on it. As Jennie said, they've been in operation now for a year. So in the first year in operation, they carried out almost 5,500 workplace inspections, and of them, just over 2,000 employers were found to be in breach of employment legislation. And actually, to be honest, I think that's quite maybe more slightly positive figure, that there's over half passed their inspection. So it's not to be totally scared. It is possible to pass. The WRC inspectors, they set out to cooperate with employers, and they do try, and they want you to pass. So I think it's a positive figure for me. But maybe not the slightly less positive, slightly negative figure is the 1.5 million in unpaid wages that they recovered. So they will be looking at that. I suppose if you look at I can't give you a list of the companies that they targeted, but it's good because there's nobody specific. It was very varied, but I think you will agree that they really are some quite significant figures. So just again, to moving on, most cases you will be notified if you're going to have an inspection. So talking about inspections, I just want to kind of go through with you what happens at the inspection and what the inspector will be looking at and how you can get that pass, how you can be one of the 50+%. In general, you will get a notification. This is just a picture of a letter. It's very similar to this, and you'll be notified when the inspection is going to take place. On the letter you will have details of the inspector's name and their individual contact details. By all means, they want you to cooperate with them, so you can feel free to contact them if you need to. If for whatever reason the date of the planned inspection does not suit you, give them a call and try and rearrange it. I would say, it's best to be cooperative with the inspector. They're not punitive in nature. They want you to pass. So it is a two-way process. Sticking your head in the sand and refusing them to come into your premises, that's not permitted, and it's obviously going to reflect negatively on you and your business. So do cooperate with them. But certainly their details will be on the letter, and do give them a call. And also if you have any questions about the inspection, the letter that they do provide is quite thorough, and they give quite a lot of information about what they'll be looking for, and they give you forms to fill in. So it's quite a useful letter as well, and it's quite helpful in helping you prepare for it. As I said, they generally do give you the notice. Only in some small cases do they arrive unplanned, and generally and typically this is if they are checking compliance against the Protection of Young Persons Act. So this is people who are working under the age of 18. So of course you can employ people under the age of 18, but there's different legislation then that just has to apply. So that's generally why they turn up unannounced, but for the most part they do notify you first. Just then at the inspection, what happens? So the inspector will enter the place of employment at a reasonable time. So this is generally during your open hours. They're not going to wake you from your sleep to drag you down to your place of work at 3 a.m. in the morning. However, that said, if your business is open late and that is your business, they may call in the evening. Just to note, they may not enter a private residence without the householder's consent. So the first part of the inspection will be an interview with the employer, prior then to inspecting all your employment records. So the data, looking at your documentation, is going to be a key part of the inspection, and this will be how they'll check statutory requirements and your compliance with those statutory requirements. So it's really important that you have your documentation in place, and when we talk about your documentation, we talk about your contracts of employment, your payslip records, timesheets, etc. The inspector is fully authorised to take photocopies of any documentation that they want to as well, and to take them off the premises. So again, cooperation really is key here. They'll be happy that you're cooperating with them. They also may ask to directly interview members of the staff to verify information that you are providing for them, and they most likely take statements from these interviews as well. Your permission is not essential here, so they can speak to the employees without your permission. I suppose all in all, your inspection, again, depending on how prepared you are and what you have in place, it'll probably take 2 to 3 hours. And again, that'll depend on the size of your business as well. So before they leave, then they will generally give you some idea of their preliminary findings. But to move on to the actual outcome, what happens once they've had the inspection? So there are 4 possible outcomes. The first will be a letter issued concluding the investigation. So basically they're saying that they visited, everything's in order, and it's just concluded, everything's compliant. If there are issues of non-compliance, generally of a minor area, they'll issue a compliance notice. So your compliance notice will state where the contravention has been. They'll give you what remedial action, they'll give details of the remedial action they want. They'll give you a time frame in which to do that as well. Your compliance notice also gives the employer an opportunity to appeal, and you can appeal to the Labour Court if you wish. In some cases, they may issue a fine or a fixed payment notice, and they may issue that on the spot fine. This is a new new ability that the WRC, the NERA never used to have this ability to issue on-the-spot fines, but they can now in certain circumstances if there have been certain breaches, namely to do with the payment of wages, that they may issue these fines as well. In certain situations where there is a recurring or a serious instance, they may go towards prosecution. In my experience, again, they tend not to. This is a last resort in terms of going to prosecution, so there's been very few cases. But what is interesting is that a full list of those companies who have received a court sanction following inspection is made available to the public. So I suppose you just need to ask yourself, do you want to be, again, named and shamed? But it says there's very few cases of that. They don't want to go that far. In terms of then moving on to your documentation and what you should have in place to help you pass your workplace inspection, and especially in relation to your record keeping, I just want to give you a little checklist of what they like to see. Just to say that this is not an exhaustive list, and very much once you get your notification, they may have specified some other information, but for the most part, these are the main parts. So you'll need your employer's registration number. This is a very, very straightforward piece. You'll have that anyway. They'll need a full list of your employees, their PPS number and their home address. They'll need start and leave dates of your staff, so leave dates of people who have left recently. So these are the kind of things that you need to be keeping on your employee files. They'll want to see copies of your contracts of employment, terms and conditions of employment. So these, again, will all have to be easily accessible. They'll want to see records of staff annual leave and public holidays taken by each employee. And it is up to the employer to gather this information and to ensure that staff actually take their annual leave. Your records with regard to annual leave and public holidays, you should be keeping these for at least 3 years. So just to be sure you have those records all to hand. They'll want to see your details of hours of work. Have you a record of hours of work for all employees? And again, this is to ensure that staff do not work in excess of the hours, the maximum hours set out in the Organisation Working Time Act, which is 48 hours per week. And they'll also want to see details of rest periods and breaks to be sure employees are getting their required rest breaks as well. So you'll need to have access to all of that. They'll want to see evidence of pay slips and payroll information, and Jenny's our payroll expert here as well, so if you're using Thesaurus or BrightPay, you'll have all that to hand anyway.
That information, just in relation to the payroll, needs to be kept for 6 years, from a revenue perspective as well as inspections. Yeah. Just actually on that, when you're talking about it, the inspector, when they come to your workplace to carry out this inspection, they may not go back those 6 years or the 3 years in relation to the annual leave. They'll generally start even just with a 3-month period, and then I suppose depending on what they find, they may ask to go back further. So they may only look originally to see 3 to 6 months, and then again they may go back. But you need to carry, again, not just for the inspection do you need this information, but for other reasons as well in terms of record keeping. Just to go on then, again, you need to have a special record for your young people. So if you are employing those under 18, there is different restrictions and different requirements for you to hold specific records for those employees. So again, just to be aware, if you have people who are under the age of 18 working with you, be sure you have their records separately or easily available. You need to have records then of any work permits to be sure that you've proper records there, to be sure that everybody is entitled to work for you. And again, they're to be held for 5 years. Well, again, just to kind of repeat what I've been said, the key to a successful inspection is to be open and honest with the inspector, and if there are gaps to identify that the inspector identifies, just work with the inspector to try and to close them and get it sorted. So if you are cooperative and accommodating, it'll look really much more favourable on you. So then that's kind of the workplace checklist, and I'm going to pass you over to Jenny now to talk about the contracts, because I think when we look at this checklist,
you can certainly gather a lot of that information with regards to the PPS numbers, the start dates, your annual leave records. But the one issue then that you may need assistance with is the terms and conditions of employment. That's what we really want to kind of delve into a little bit more.
Absolutely. So why are they so important? Your contracts of employment. So in terms of the employee/employer relationship, the contract of employment is the most important thing you'll deal with. It's the foundation stone of the relationship that you have, and really we can't reiterate it enough how important it is for employers to get their contracts right. It'll clarify certain conditions for the employee, but for the employer it'll offer protection, and it can be used as your go-to guide in the event of a dispute. So just on that, before we delve in any further, we're going to ask the question, do you have contracts of employment in place for your employees? So we're going to open a little poll. So in your little field there on the right hand side, if you can type yes or no, then a little later we'll do a quick count and get the stats.
Yeah, I'm just going to leave it up for a moment. The results are coming in, so we'll leave it up for 30 seconds or so, and the results are coming in.
We promise it is anonymous.
Yeah, absolutely.
We don't know who's saying yes or no to this, so
yeah, please be honest.
We'll see if that changes the momentum of the yes and no as they go in.
It's actually coming in quite consistent. It's fluctuating a little bit, but I think we'll hold it there. And I think we're looking at about 70-30, 70 saying yes, you do have contracts and employment in place, which is fantastic. Okay. And for those who don't, hopefully we might highlight this. So I'm just going to close that off now. That's closed now.
Great stuff. Thank you for contributing to
Great,
it. Yes. If we move on, then what we'll show you here in a recent survey that Bright Contracts conducted with employers, we actually found that up to 60% of employers do not have contracts of employment in place. Now, coming from a payroll and employment law background, this to me is absolutely staggering, particularly when it is a legal requirement that all employees have written terms and conditions of employment in place. And really, when I saw this stat first, I was a little bit taken back by it. But never mind me, you guys working in businesses that actually employ staff, you're the ones that need to be concerned about this. So looking at the contract itself, who gets a contract? We tend to come across it on the phones quite a lot. I only have a couple of full-timers, and they all have contracts. And I've a couple of young fellas who come in at the weekend or for a few hours during the week, but I don't really need anything for them. So there seems to be this myth that only full-time employees need contracts of employment. That's simply not the case. Anyone who's on your payroll should have a contract of employment. Part-time workers, even if they're only working for a couple of hours a week. Seasonal workers that come and go throughout the year depending on your industry. Maybe it's covering workloads over Christmas or during summer, during the picking season. They need a contract of employment. Temporary, fixed term, specific purpose, somebody coming in covering maternity leave, they need a contract. Casual workers, the person you call when somebody rings in sick.
This going back to our gig workers.
It's the gig workers again, exactly, yeah. When you need to call on somebody, he needs a contract. We generally tend to find that these if and when contracts play a massive role for the small businesses and actually give business owners the flexibility, as Laura spoke about earlier on, that they need to be able to run their businesses. And whilst they're important, it's the casual contract that really needs to have that clarification put in place, as there is such ambiguity on that area. So as I would say to anybody, once there is somebody on your payroll and you're giving them a salary or a pay slip every week, they should have written terms of their employment, and they should have this by law within 2 months of starting employment with you. Realistically though, from a management point and best practice, we advise employers to issue the contract on the employee's first day, if not before they actually start. Okay, so what's included in the contract? The Terms of Employment Act 94 imposes an obligation on the employers to furnish their employees with a written statement of certain terms and conditions of their employment. Those terms and conditions that have to be provided are the full name of the employer and the employee, the address of the employee as on the company registrations office, The place of work, so where the employee generally comes to on a daily basis to work. Now, if there is no permanent place of work, there should be a statement specifying that the employee is required to work elsewhere or at various locations depending on the job spec. The title or description of the job or the nature of the work, the date of commencement of employment or that of the contract if it's an updated contract. In relation to fixed term or temporary contracts, the expected duration or expected termination date of that contract. The rate of pay, method of calculation, frequency of payments, so how often they're getting paid, if it's paid weekly, by check, their hours of work including overtime, the notice period required from each party to terminate the contract, your terms and conditions relating to sick pay or any pension schemes that you may have, terms and conditions relating to paid leave, if there is any, and if there's any collective agreements that may affect your particular industry, and they also need to be recorded there.
Yeah, they're generally, if there are trade unions in place, I find a lot of our small employers wouldn't have collective agreements, but it's certainly something to be consider. Jenny, you've just kind of talked about the pieces that must be in the written statement of terms, but I always recommend, and it's common practice as well, that there are some additional clauses that you really should put in as well, from an employer's point of view, that will offer you greater protection. A lot of people say, well, the contract is very pro-employee, but you can certainly add clauses in that protect your business, that are in addition to the statutory minimum. They not only will they protect your business, but they can provide greater clarity in the relationship and hopefully avoid disputes, should they. Conflicts is the word I was looking for. And as I said, they'll definitely protect you. Exactly what additional clauses that you should put in really will depend on the role that you were recruiting for this person. So just on that, your contracts will never be, they'll be different for the individual, and you can certainly tailor your contracts depending on the individual themselves. If their senior management might have a different contract to your entry level people. And again, the additional clauses will depend not only on the role, but they'll depend on your own company and the industry that you're in. We've listed some sample best practice clauses that really should be in your contract, so we would recommend. And the first one is your probation clause. I'd put that in across the board, really, because you want to protect yourself. Again, how the probation clause will discuss how you are managing the employee during the probation, just to set out guidelines that should and not work out, because the reality is not all hires do work out. A pay in lieu of notice clause. Again, this is a very useful clause when you get to the end of the relationship, when the employee is leaving. So it's, again, a very useful clause. The bonus clause, again, that's a really useful clause. I think Jenny might be talking a little bit about more of that in a little bit more, a few more minutes. But this is to really protect your company. If you as an employer, you think you're doing something well, you've got a little bit more cash flow this year, and you offer a bonus, and you've offered it for a number of years on the trot, and then the next year things aren't so good, and you decide you won't pay the bonus. If you don't have a clause in your contract to say that any bonus payments is made, at the discretion of management, you could find yourself in a case that custom practice has set in, and you have to pay that bonus. So again, this is a really good example of where a nice clause in your contract can protect your business. The layoff and short time working clause. I think we get a lot on this on our phones, particularly again from the small employers.
Yeah, I mean, it's something that, as Laura said, we do recommend you put into your contract for SMEs generally. Kind of with the way things went over the last few years, employers need to have that flexibility in place, that if they're in an industry where they could have worked one week but possibly not the next, they need to be able to fall back on that without having to let employees go. Yeah. But kind of have it in place that they can kind of not pay them for a period of time if they need to. Yeah.
It's a really useful clause to have. Yeah. We'll touch on it again in a minute. And then just quickly, time and attendance is a great clause to help you manage situations. People coming in late is often one, or leaving, taking sick leave, holidays. Time and attendance can again help you manage those. Post-termination restriction clauses. Again, this is one which will very much depend on your industry. But for example, they will set restrictions on what an employee can and can't do once they leave your employment. So we would have a number of, let's just take the examples of pharmacies, and the pharmacy is working in a small town, and they don't want Mary, the pharmacist, to leave with them, set up 2 doors down, and take all their customers. So your post-termination restrictions, once reasonable, can certainly protect your business once the employee leaves. And then just some general reference to company norms. So this is just a sample of the additional clauses that you can put in your contract that will help protect your business.
Now, just in relation to the cost of non-compliance on this, if you think of an employee, think of their weekly wage, multiply it by 4, and just picture that figure in your head, because that would be the cost of non-compliance with the legislation. If you're found not to have contracts of employment in place for your staff, you can face a fine of up to 4 weeks' pay per employee. So if you have, for example, a small cafe, you have 6 waiting staff, and on average they earn €320 a week, there's a fine there of up to €7,680 for not having a written statement of terms and conditions for those.
Just when you're talking, just something's popped into my head there. It's never too late to put contracts of employment in place. So if you have a situation, you don't live in fear that you're going to get found out, put them in place. It's obviously it'll be benefit to you to that people can see that you've rectified a wrong, if you like. And so even if you have somebody working with you for a number of years, it's never too late to put a contract of employment in place and to agree that with the employee. And I think generally, for the most part, once you discuss it with employees and explain what A, B, and C clauses are, you'll find that they agree.
That tends to be, something that does come up over the phones as well, that, I've had Mary working for me for the last 10 years. If I go introducing a written piece of paper saying what her terms and conditions are, she might think I'm trying to add rules in there that aren't necessarily effective. But realistically, whether you have a piece of paper with the terms and conditions, there is, as you said, practice and custom there. There is a contract in place, whether it's on a piece of paper or not. But legislatively, you are supposed to have the terms and conditions given to the employee within the 2 months of starting. So from a legal standpoint, it is better to have it as a contract of employment.
And we know we've talked about, where we're speaking to employers here, we talked about how you can protect yourself. There are certain things in the contract that can help protect the employee as well. Now, if we get really technical about it, people say, well, Mary has been with us 5 years and she's not going to sign. She was refusing point blank to sign the contract. Don't get overstressed about that. Take the steps that we've talked about, and we have some guidance on our website as well as to how to roll out contracts. But as an employer, if you can show that you've issued a contract with the written terms and you've given the opportunity to the employee to ask questions, to discuss different types of the contract, and you've got a record of that, that's fine. The employee does not actually have to sign the contract. Obviously, it's best practice that they do, and you definitely want to work towards that. But but at the end of the day, by virtue of the fact that they're coming into work every day at 9 o'clock or whatever it is, and they're taking their wages at the end of the month, they are essentially agreeing to it. So it's actually better for them to sign it, with maybe a note to say whatever clause isn't. But I've definitely gone off tracks there. I could talk about this all day.
It's one of those things that literally just, because it's so kind of varied, employers do tend to get scared. But as we're trying to kind of prove here, it can be very easily rectified. So just before we go then, to protect against costly disputes, recently an employee who had not been furnished with written terms and conditions was awarded €1,200 straight off the back under the Terms of Employment Information Act by an employment tribunal. So whether that be by an inspection or the employee made a complaint to the WRC or the adjudicator, the tribunal basically felt that because she hadn't been given them, that she was due this award of €1,200. It does leave you open. It can leave you open to the fines, but it's the disputes which can then escalate into tribunals if you're talking about legal fees on top of that then. So not having clearly documented terms can really leave you open. So just as an example of this, when Laura was saying earlier on about your terms. There's two types of terms. You've got express terms, so those that are in writing, and then there's implied terms, which are unwritten and tend to have developed over time, like that custom and practice. The implied terms can be formed as a result of custom and practice. The custom and practice is a practice that has been developed over a period of time or by arrangement that has never actually specifically been agreed upon between the employer and the employee, but could be argued to have formed part of the terms and conditions. The problem is with the custom and practice is that there can easily be that disagreement. A recent case there involved a publishing company where as such there was no written policies existed outlining bonus payments. The employees were obviously paid a bonus on a regular basis, but then the employer got into financial difficulty, but just came to a point where it wasn't feasible to pay the bonuses out. The employees obviously complained, and the judge stated that in order to establish a fair, reasonable and just approach, he had to find in favour of those employees. So because the employer didn't have that written policy there, outlining what the payments of bonuses were to be based on, or when or if they were to be given, and because they had been given in the past, the judge found in favour of the employees because it was practice.
Okay, interesting.
So your policies and procedures. So this really is the holy grail when it comes to dispute. And some could actually say that the company handbook or the employee handbook is actually as important as the contracts, as this contains the details of the steps that need to be taken by both parties if and when there are disputes or grievances. And as Laura mentioned at the start of the webinar there's 30 pieces of legislation covering employment law in this country. And the main pieces of legislation are the most important ones we're going to look at now shortly, but really should be the starting block for a company or an employee handbook. So what's in the handbook? Sorry, your policies and procedures. Basically the descriptions of how all employees, regardless of their jobs, their titles or descriptions, are expected to conduct themselves. So the employee policies and procedures are typically contained within an employer or company handbook. And having a handbook in place really gives you the opportunity to set out in detail what you expect from your staff. And there's a good old wives' quote, good fences make good neighbours. And this is certainly true because it reminds us that good boundaries and clarity between two parties leave less room for dispute or rows. And really that setting the groundwork at the very beginning of a relationship hopefully will just waylay there being any issues further down the line. So as it is with the employer-employee relationship, the more clarity and less ambiguity, the less likely there will be costly disputes or claims later on. Now make no mistake, the most essential document governing the employment relationship is the contract of employment. However, staff or an employee company handbook can be so useful, especially when you want to communicate essential policies and procedures without the contract having to become too long and unwieldy.
Yeah, absolutely. You really want to keep your contract fairly concise and to the point, but the handbook is a great place to put all those extra policies in.
So what's in the handbook? Basically you've got your legally compulsory components. This is the likes of your dismissal procedures. You're highly recommended. So these are policies that will be key in helping you avoid any kind of employment disputes. So the likes of your grievance and equality policies. And then what we would recommend or what's recommended to put in your handbook. So we'll take a look at those a little bit later. So taking a look at the dismissal procedure. In order for an employer to dismiss an employee, even in the instance of gross misconduct, you are expected to have a clear and documented procedure in place and have followed it. Generally, you know, if you do get to the point of standing in the tribunal or in front of a judge, all that judge wants to see is that you took fair procedure in actually dismissing this employee. And really, if you have a dismissal procedure in place in your handbook, the steps are there. All you have to do is follow them. Really, it's not a case, as I said, even in the instance of gross misconduct where if somebody does wrong, you cannot just fire them. There is procedure and there's protocol that has to be taken before you get to that point. So generally, it's included as part of the disciplinary procedure in the handbook. There is a legal obligation on employers to supply all employees within 28 days of starting with the details of the procedures that an employer would follow when they're dismissing an employee. And we really can't stress enough how important it is to have that policy in place so that everybody's familiar with the procedures and steps that need to be taken before somebody's actually dismissed. If you don't have a written procedure in place and you dismiss somebody, any judge in a tribunal will basically just throw it out. And it's as simple as that. You will lose if you get to that point. So if you do take just one thing from the webinar today, have a disciplinary procedure or policy in place. It's too late to try and roll out policies once you've actually got a dispute or an employee is bringing an issue to you. The disciplinary procedure and policies will act as your framework. So if you want to dismiss someone, that's your first point of call, and it's your reference guide. It's your step-by-step guide, basically. And just to reiterate that, an unfair dismissal case recently saw an employee awarded €94,000 because the employer dismissed the employee without any procedures whatsoever. Now, they did have a dismissal policy in place, but I think the company was trying to wind up and thought they might get away without having to pay full redundancy, so they did it on the QT. The employee obviously understood that she was due a lot more and basically got awarded nearly €100,000.
Yeah, and it can be hard for a small employer, especially if it's your business, and if somebody does something wrong or wrongdoing has taken place, it's very hard not to take it personally, and often we see businesses reacting personally, and sometimes you feel that there's definitely a definite reason for dismissal. And there's a case on this as well where there was a truck driver who turned into work very obviously under the influence of alcohol, and as a truck driver you would consider that pretty bad. And the company dismissed him, but they dismissed him there and then, and it went to court, and it was found in favour of the employee, because yes, you had a fair reason for the dismissal, but it wasn't processed fairly, so the procedure has to be done fairly as well. So that's why the dismissal procedure is so important. Just further to that then, kind of hand in hand, I suppose, the grievance procedures tend to go with the disciplinary procedure. So a grievance is a formal expression of dissatisfaction with a workplace relationship. With the workplace relationship, or within the work environment, or regarding a term or condition of employment. I see it really as just as important as the disciplinary procedure, because it provides your employees with a course of action or a route to go with should they have some sort of a complaint which they've been unable to resolve through informal discussion with their manager. And it provides points of contact to go with for the employee, and it provides a timescale. Why I think it's really important, to be honest with you, is because if you have a grievance procedure, and similar to the whistleblowing procedure, if you set out, if you have a problem, you go to A, B, and C. If you have that procedure in place and the employee doesn't adhere to it and goes off and does their own thing and immediately brings a case to the WRC, the first thing the WRC is going to say, well, employee, you didn't look at your internal grievance procedure, so I'm not going to listen to your case, or is likely to throw the case out because they didn't go through all the avenues internally. So again, a grievance procedure can really protect you, because it allows employees to bring a case internally and gives you the opportunity to resolve it. And that's all I'll say there, because I'm conscious of time as well. Other highly recommended policies, Jenny's already touched on these, is the equality policy. And this is a great policy, and we'll touch on it in a little while again. But the equality policy can act as a really good guidance for you as an employer. We have a really good policy, and equality policy, and it'll touch on things like recruitment and selection, training, promotion, all these things in the organisation that you want to avoid any kind of discrimination claims, and you want to be sure everything's fair and above board. If you've got a good equality policy, that's going to act as your guidance. So if you have ever any questions and you think, well, I'll just check that in my equality policy, and it shows you again as a very conscientious employer. And also bullying and harassment, they're again really highly recommended. When I talk about actually grievance and equality, we've got code of conducts that WRC have set out on these issues. So a code of conduct is not, while it's not legislation where we have to have a disciplinary procedure, it's almost like the next best thing. So again, ignoring these, you do it at your peril, I would say.
You've then got the likes of your recommended policies and procedures that you can put in. I'm not sure that we actually have time to go over these, but when we're doing the demo, maybe we can take a quick look. The likes of your family-friendly policies, making sure you have your, paternity leave clause in there, your maternity leave, etc., and details on holiday pay. Internet and email use would be a big thing now. If you've company cars, if you're dealing with customers or public, your dress code, and things like that. But we'll look at that a little bit more in detail when we're going through the demo. So take a look at them yourselves as well.
Yeah, I'm conscious that there's some really interesting questions coming in as well, and I do want to give them a bit of time as well. So we've put in a few key considerations here, and again, I think we'll probably touch with them when we go through the demo as well.
Yeah, I think when we're looking at the handbook, maybe we can just flip back to the key considerations, or I'll take a look at that then. Yeah.
Yeah, we are recording this demo as well, and you'll all be sent the recording afterwards as well, so you can look back at it at your leisure as well. And just before we move on and take questions, just to, if you're enjoying today's webinar, we have another webinar planned on the 30th of March, and we're looking at dismissal, as we've just touched on.
Initially touched on.
Yeah, there's mine.
We'll spend a bit more time on it.
But again, there'll be a link to join that at the end as well. So I'm just going to take some questions then, because there are a lot. So bear with me until I just open up that screen and we'll get to that. And then once we go through the questions, what I want to do is, obviously contracts and handbooks has really come up and come to the fore here. And we want to just give you a very short demo of the Bright Contract software and to show you what it entails, how easy it is to use, and how it can help your business. But to answer the questions first, bear with us now, we'll just kind of get set up and get going here.
Somebody's actually asked there, do we provide video? So as Laura's just said, we are taking a recording of the webinar, so that will be sent to everybody who has registered a little later on. Yeah. We should get it done today.
Yeah. Oh yeah, please go. Slightly off topic, but it's come in about bank holidays. If you have a new employee starting, and she's starting the week of St. Patrick's Day, and obviously St. Patrick's Day is on the Friday, is she entitled to the bank holiday? As she is a full-time employee, I was saying yes, she would be entitled to it. If she was a part-time employee, it'd be slightly different, but a full-time employee should be entitled to a bank holiday.
We have one there. We have one store where some staff are so long in place that they feel they have unwritten contracts and refuse to sign a new contract. How best can we deal with this? Well, as Laura said there, we have details and information on our website under the documentation of how you can actually implement contracts. And as we said before, I mean, even though it's not there in paper, it is, better for the employee to have that signed written terms and conditions of employment themselves.
Yeah, your employees are probably right to a degree that because they've been there for a number of years, they do have unwritten contracts in place. So you just want to be sure that when you're implementing a contract that it reflects the practices. You don't want to implement a contract that is totally in contradiction to what's happening in your organization already. And if you are making changes, well, then that's a negotiation process. But if you're basically just putting in writing what's already in existence, that shouldn't be a problem. And again, it's all about the negotiation and showing that you've been open to taking their queries, and hopefully you can get an agreement with them.
Yeah, I mean, it comes down to the communication as well. I mean, if you're going to be hooded and dark cloaked about it, they're going to think something's up. Yeah. I mean, if you keep the line of communication open and be honest with them, there's no need for them to be worried then, really.
Yeah. Just another one here. Do staff need to clock in and out when they take breaks? Not necessarily. Not all organisations have a clock in, clock out system, but you need to have some way to record their hours worked. I know there is the OWT1 form, which is a sample form of keeping records of people's time if you wanted to use that, or if there is some way that you can record time. You don't have to invest in
an expensive clock-in system. You just need to keep a record of it for the likes of the inspection.
Now we're just reading as we go here, so and there's a lot of questions, so we might miss some of them, but we'll go back afterwards as well, because we're just trying to pick out some of them. What about, sorry, there's one here, what about people on work placement but are not paid? I'm presuming the meaning behind that is, do these people get a contract? So I suppose that depends, and not to just try to shy away from the question. Obviously, Jennie has already said that employees only need a contract after 2 months. So if they're only there for a very short period of time, if you're taking on a transition your student for 2 weeks and you're not paying them and they're just there to help out, probably no, you're okay. If it's somebody there who's on anything like a longer time, even a month plus, I would say put in an agreement in place. And the fact that it wouldn't be a contract, but some sort of an agreement, a document, because what's happening with that person is that they're on a work placement. It's obviously a training scheme, and you want to be very sure that you specify this is a training scheme and that they're not essentially working, because then you're getting into the whole realm of, well, if they're working, should they be getting paid minimum wage? Yes. So I would say put something in, if they're there for a decent amount of time, put something in place, clearly saying things like what are their learning objectives whilst they're with you, and what they're supposed to be doing.
Well, what they're going to be trained on, I suppose, for their own records as well.
And actually, there's another question here for apprentice. We have some guidance on that. I might come. I can contact that person afterwards as well, just for what to do for the apprentices as well. But again, they should have something in writing, and the type of thing that it'll be saying, is their training plan for the period that they're there.
What do you need in a contract for relief workers and casual workers? I mean, it's basically their terms and conditions. I mean, it's their working hours, what you've agreed with them. If they're casual workers, you need to state. Sorry.
Yeah, fine. You need a lot of the things that Jennie has already gone through on that list, because we don't define any difference in Irish law between a worker and an employee. They do in the UK, but we don't here. But essentially, if they're going to be an employee for you, you need to specify the same things, like where the place of work is, what their wage rate is, how they accrue their holidays. If it is an if and when contract that you're literally just calling them when you need them, you'll need to kind of give some clarification on that. Yeah. And again, we have sample wording on that, and we have a lot of our customers would have that type of employee working with them, and the Bright Contract software allows for that as well. So we can show you that as well in a little bit of detail. But the core of it will probably be very similar. I see we've got one. Somebody, God loves a trier. He's looking for a discount because he uses Bright Pay. And we actually are offering a discount today on Bright Contracts for everybody who is on the webinar. And we're offering 15% off our regular price. So usually we're $149 for a standard and $299 for a bureau. We're offering 15% as well. So that's come up.
You cannot put the price on having contracts of employment to company handbook in place. Literally, if it came to a dispute, that the cost is never going to be enough. So 15% is actually very good discount on it.
I see somebody just probably come up as a result of my answer to the previous question to say that they thought a bank holiday was only given if an employee had worked 40 hours in the previous 5 weeks. That's absolutely correct if they are a part-time
employee. Anybody, regardless of their status of employment, whether they're full-time, part-time, would be entitled to some form of payment for a bank holiday. Generally, that rule in relation to the 40 hours and the 5 weeks prior to the bank holiday applies only to part-time workers. If he's a full-time employee, he gets the full entitlement of the day off within a month, the day off that day, or an extra day's annual leave.
I just see one here on retirement, and it's an absolute minefield, is what I would say. Legislation changed on retirement last year, actually, to say that it's no longer... how do I word this now, the most straightforward way, you may only put a retirement age, a compulsory retirement age in a contract if you have reasonable objective justification. So that if you have reasonable reasoning as to why you can put that retirement age in. So it's no longer okay just to say, well, 65 is our retirement age because that's what it is and that's what it always has been. You need to be able to objectively justify why you have that. Now, we've written a lot of guidance and blogs on this in the past. The type of things that the courts or the WRC will be saying is acceptable, again, will vary depending from your organisation, but the type of things might be health and safety reasons. And there was a case where Lewis drivers, they theirs was okay, their age was okay because of health and safety concerns for the drivers once they hit a different age. ESB won a case to say they had recruited or they had put in a retirement age because they wanted to maintain opportunity in the workplace and allow for promotion and for younger staff to develop. So they're the kind of things. The person who's asked this, I can send you the guidance notes that we have on it. We allow in Bright Contract software for you to put a retirement age in, and then we also allow in a handbook for you to put a policy in to say why you're using that retirement age.
Okay, so somebody's asked there, an employee has applied for paternity leave to begin on the baby's due date, but now has asked for the leave to be taken earlier as the baby was delivered early due to complications. Can he change the dates of his paternity leave at such short notice? Really, that's going to be down to the employer.
Yeah.
I mean, the paternity leave, the employee is entitled to take it up to 26 weeks after the due date of the baby or the date of placement of its adoption. So really, that's going to come down to the employer whether or not you've got staff to cover the leave.
I think the legislation states that they must give you 8 weeks notice in writing if they want to change it. You know, in reality, that's not always possible when we're talking about
emergencies.
Yeah. So again, it's down to you. You know, if you can maybe reach some sort of a compromise. Do we need a separate handbook for dismissal procedure, or can they be? Oh, they can be. Your dismissal and your disciplinary and your grievance. Your dismissal procedure will be part of your disciplinary procedure. So the disciplinary and your grievance, absolutely, they're part of the handbook. You don't need anything separate. They'll just be in your handbook. We're just reading. We've received this any more. They keep coming in, but it's great to get all your questions. If we don't get to them, as said, we will go through. We'll go through them afterwards, trying to.
I think maybe what we might do is there is a few more coming in there, so we'll get back to everybody individually on the questions, unless you can see one there that we can answer quickly, just because we're conscious of the time and we want to move on to the demo of the software. Okay. So anybody we haven't answered, we will get back to you.
There's one last one. I'll do one last one. We'll do one last one, and then we'll move on to the demo. And if people want to stay, we'll see. Do I have to make an employee permanent if the probation period in the contract is up, or can we just extend the probation? And if so, do they need a new contract? So this will really depend on how your contract is worded, I suppose. If I have a new employee starting tomorrow and I give them a permanent contract, is what I generally would do, and it's the type of contract that Bright Contracts would present or creates. Part of that contract, there is a probationary clause in it. If then after, let's say, 6 months, I'm happy with that individual, it's just it's an indefinite contract, continues on. I don't need to issue them with a contract unless I've just issued them with a 6-month contract initially, and then after 6 months, then I would give
it needs to be reviewed after the 6-month period.
Yeah. But just on that, if it's an indefinite, if a permanent contract I give, and once the probation date goes over, I can't then say all of a sudden, oh no, you haven't passed your probation, I'm terminating you now. You have to be careful that once the probation date is over, you need to be conscious of that there as well. Is that okay? Okay, we'll come back to some of the other questions because we do want to show you the demo. I know some people are probably hanging on for it as well.
This is what you've all been waiting for now. Show you just how easy it is to get all this legislative requirements, 30 pieces of legislation covered quickly and easily.
Yeah, in a 5-minute roundup demo. So if you're familiar with using Thesaurus or BrightPay, if you're familiar with the concept that it downloads as a little icon onto your desktop. So that's exactly what happens with Bright Contracts. And I've just opened it up here. I have a company screen, and it allows me to open it up, and it opens up initially in this summary screen, which I think is a really, really useful at a glance overview of where you are and where you're at with your employees. So it gives me these little nice pie charts: who has a handbook, who has an out-of-date handbook, who hasn't signed their contract, who, this is really useful one if I'm talking about my short-term workers, well, who's expiring soon. It tells me then over on this side on the left what sections of my handbook have I recently updated, and what I really like in this top box here is the handbook versions, because I know working in HR, I make changes to my handbook and then I've got 5 different versions of the handbook and I don't know which one is the most recent one and where did I save that last one. What this does is it just makes a record of them all, so I can see that if I click into any of these documents, it'll just open for me in the handbook and I go, oh yeah, that was the handbook that we were using last year, but now we're using the one in the software here. So again, it's just a really useful tool for managing all these documentation, because it is a lot of paperwork as well. The software then, in the file box, it's you can import and export data. Again, if you're using our payroll software, it's really useful to get your initial information up as well, and you can create snapshots as well.
And just snapshots being a backup.
Yeah.
Some people get confused with the snapshots. It's the Bright Pay, Bright Contracts equivalent of a backup of your details.
Perfect. The 4 tabs across the top, these is where I'm going to do most of my work. So this is my summary screen. Click on my employer. These details, they automatically go in once I create my file. And as you can see, I can add in a company image, again, just to tailor the documentation. Because when we're talking about your handbook, it's very unique to you and your company, so you can tailor it there. The JLC agreements here, we talked about the contract cleaning ERO. There's only 2 actually in operation at the moment, but we have full details on that, and there, that's all in there as well. So there's a huge amount of information and background reading there, but it shouldn't apply to too many people at the moment. I'm going to skip the handbook tab for a moment because we'll go back to that, because I really want to show you how to create a contract. So move into my contract screen. My employees are listed here along the left-hand side. To add an employee, again, I can import them using the file importer, or I can manually add an employee, clicking new employee here. And I can just put in their basic information. Again, I can add a picture if I want to glance at them. But I'm just going to work off the employees that I have. As you see here, under each employee, I have Glenn, Ryan, and then if I click on Glenn, no, I don't save those changes. I go into Glenn and I can see his basic information there. And I can also have this notes tab, and I find this is a really useful box again. If I just want to keep a quick record of next of kin details, or when somebody did their last health and safety or first aid training course, just this kind of, it's a really useful place to keep your notes in.
That can be handy as well if you did have a meeting, like a disciplinary meeting. You can take notes, or minutes of the meeting can be recorded in there as well, and on the individual employee files. So it's handy just to have them in one location.
Yeah. Absolutely. So that's just the overview on Glenn. This date underneath Glenn here, that's his contract. So every time I create a contract for Glenn, it shows up here. And as you can see, there's 6 tabs across the top that are involved in creating that contract. But I want to create a contract for you. So this, I'll just pick Robert Parkinson here. He doesn't have a contract because he has no date under his name, but I want to create a contract for him now. So I'll click on his name, and I can see his initial information. So I go up here to create a new contract, and I have 2 options. I can use Bright Contracts default settings, or I can copy from another employee. So if it is that I've got 7 waitresses, floor staff in my business, and I don't want to have to go through each one and recreate the wheel every time, I can just go in and I can copy somebody else's, and it'll just populate it initially for me. Again, it takes a lot of the work off for me. So again, as I said, you have 6 tabs across the top, and we just need to work through all of them to create our contract. Waiter and with job description, and I'm just going to type in some of this really quickly. I can see these little brown information snippets. If I click on these throughout the software, it's just little tools and information snippets to help me complete the contract. And the rate of pay, I've taken that from Glenn, so obviously he's paid €10 per hour, but I could say if that was, if I can change that to say he is paid €20,000 per annum, and he can be paid weekly or monthly by check or by credit transfer. So again, that's just what you have to have. Going back to what Jenny said, what you need to have in your contract of employment. I go into my dates and when was this contract created? When did this employee start commencement with me? So that's kind of, again, going back to points that we discussed. You might have somebody who's been with you for 5 years and you think, oh, I need to get these contracts in place now. It's very important that you replicate what's been happening, and it's very important, one of the key things is that you recognize their start date. So you want to put in when they actually did start with you, because you want to recognize that service. So you can put that in here, but you can obviously write the date of this contract. Even internally here, when we're doing contracts for our own staff, every so often we renew our contracts just to make sure they're up to date and they're reflective of things that are changing internally. So I would issue new contracts to our staff, and I always recognise their, if somebody has got a pay rise, or if they've changed their hours, or we've changed their holiday procedure, whatever it is, we'll issue a new contract, and we just recognise their start date, but give today's date as well. Probationary period, we include this automatically, but you can exclude it again if you're renewing a contract, and where you can put it in. And just by putting in that little tick, you'll see when I show you the contract that we have a full, really conclusive probationary period policy or clause. And I go on to this, the place of work. Where is this place? And it defaults to your employer's main address, but obviously if that is different, you can certainly change that. That's a free text box, and you can type in there as you want. Tick if they're required to drive, tick if they're required to work elsewhere, and tick if they're required to work outside the States. This is kind of information, again, that you need to be putting in. I'm going to move on now to the contract type. In this contract type, Jenny's dying to get it.
No, this is what we always get questions on. And it has come up a few times in the questions that we've got in from the participants there. Your contract type. Especially when it comes to the casual workers, the fixed term workers, again from over the phone when people say, but sure, it only comes in for a couple of hours a week. I really don't need to give you a contract, do it. Really, you do. And it's so important that it's written down and you've stated their terms and conditions. Again, we just can't reiterate that enough. So sorry, I just wanted to say that again.
And just kind of follow on from that, there is, although this is a piece of software that goes onto your PC locally and you have full control of managing this, there is full support on the phones to take you through all of these and talk you through. We would have people ringing us up saying, well, this is what Johnny does. He does this, this, and this, and we'll kind of work with them to get the right wording, if you like. So just to say our contract type, and I'm looking at working schedule at the same time because I want to show you that depending on what I pick here, the boxes are going to change. So the software is really intuitive. Just for example, to pick a fixed term, right, what I need now is to say how long is this fixed term working. So the software is putting in this extra date here, and I can choose a date of how long the fixed term contract is going to last. If I was picking casual hours, again, my if and when, there's a lot more flexibility there. So I'm not restricted in these boxes of what times. So again, we have this free text box. We grey in some sample wording, and again, this is an area where you really want to be using our help guides, and we have a link here which brings you onto the website, which again gives you more guidance. So there's loads and loads of support here. But what I want to say is if I click save down the bottom here as I go, it's not going to let me save because we're saying, right, you're putting in some information and legally now you need to go the next step and you need to put in other information. So again, you can be kind of rest assured that once you get to the final setup, you've got a good, fully comprehensive contract. And just to say, we would have a number of, for the sake of this contract, I'm going to just go to normal because it's easier. It's in there by default. We'd have a number of our customers who have had WRC inspections, and their contracts, TrueBright contracts, have been inspected. And they've passed, and it's all been fine for them. So again, just for ease, I'm going to pick that this employee is permanent. If normal hours, it's 9 to 5. Again, that's all changeable. Whatever suits you, Monday to Saturday, whatever works. And then some of you have any exceptions. We come in earlier here ourselves one day, we leave earlier a different day. So you might want to just tailor that in. And again, there's full free text boxes there just to give you that flexibility to put in those nuances that are particular to your company. And then Jenny touched on details of any collective agreements. So this is where in the software you'd put that in if applicable. So I'll move along. I find I'm trying to tell people that this is really easy, but I'm talking so much that
It is very easy. The software is very intuitive, but as Laura's just pointed out there, it won't allow you to kind of bypass certain steps. Depending on what you've selected, it knows that if you've selected casual hours, you need to fill in details of what that arrangement actually is. So the software is very intuitive in that regard.
We go on then to overtime. Is it paid, unpaid? And this is a really good free text box. I love it as the nerd in me. And you can put in other details of your remuneration here. But again, in our information snippets, and we discuss bonuses. So we already have talked about bonuses, and it's so important to put in your bonus policy. So if you are paying bonuses, will be where you put it in this free text box as well. Accommodation provided, again, if you do provide accommodation for staff, you need to make reference to that in your contract as well. Annual leave, we default to the 20 days, but again, that's all changeable. Your annual leave year might be January to December, but you could change it to April or March or whatever it is that you're doing locally. Your pay in lieu of notice, we've touched on that as well. We defaulted to include it because it's best practice, and I'd recommend you include it in your contracts, but you can equally take it out if you don't want it. Sick pay, again, if you have a sick pay scheme where you are employing or you are offering a sick pay in addition to illness benefit, you can tick it here, and what happens is a nice free text box appears for you to text to include that. If you leave it unticked, I'll just show you in the contract when we view it, because you do need to include details of sick pay in your contract, so I want to show you then what we include again, just to,
that's the default.
Yeah, that is fully correct and protects your business and ticks all those boxes of what you need to put in. Miscellaneous, then we go on to rest breaks. Are they paid? Are they unpaid? How long are they? Any other kind of nuances you want to put in? Notice on termination. What is the notice? How much notice do you want to give an employee, and how much do they want to give you? So you can default to the statutory notice, or you can increase it. I would generally recommend increasing it, because you find that if you say, we say here, what notice is required for termination of employment by the employee? So the company is going to give me a month's notice, but then the employee only needs to give me a week. So it's not really fair.
It's not fair, no.
So it's quite common practice that you would match it. But that's that there. In regard to sick leave, how long can an employee be out without providing you with a doctor's cert? There's no statutory limit here or guideline, but it's just best practice to help you manage sick leave in your organisation. We use a default of 2.
That free text box, actually, I'm sure you're going to touch on it, it's something I learned off you. It's something that I like to use, the notice of absence requirements. And one thing, just given the era of social media that we live in at the moment, we would advise that you put something in there to say that the employee needs to make direct contact to their line manager or their HR manager themselves, that it shouldn't be made by their spouse or partner or mammy. And that it needs to be made in person by phone, and that a text message or a message over Facebook would not be adequate, and certainly wouldn't be received very well by the employer.
Yeah, if you put that in your contract, it just when the situation arises and it's at your door, it makes it so much easier for you to manage it as an employer, to say, right, well, actually, no, you cannot just text the person you sit beside. You need to call me, and that's the policies. And then, if it becomes a reoccurring issue, then it's much easier for you to discipline that and to deal with it. So again, the free text box there is great. Just retirement age, because we've had a question on it, the system allows you to put in a retirement age. We default it to 0, but of course, whatever you decide in your organisation can be put in, and we have full, again, guidance notes on it. We talked about pension as well. So one of the key things that we talked about then earlier on was the additional clauses. So as it stands, that we haven't gone through all these tab boxes, we have a good contract in place, and I can view it, I can print it off, and it's ready to go. But you might have different employees that need different clauses that we talked about: your post-termination restriction, your layoff, your confidentiality clause if you've got somebody who is has access to either customer information or financial data.
Just that you mentioned that layoff, that short time clause, that is something that comes up quite a bit, and is something that we would recommend. Again, we touched on it briefly earlier on. We have it there, I think, in the additional sample section. So again, down to online documentation that we have available to you when you use the software, where an employer's business fluctuates, and they could be working one week and they mightn't be working the other. Having a layoff or short-term policy in the contract or clause in the contract. Just it basically safeguards the employees. It allows the employer to kind of organise work and get things into place. So it's just advisable to have something like that in there. And again, the sample additional contract, there's a few options in it. The layoff short term, the confidentiality agreement, payment in lieu of notice, that's part of the contract anyway, but the restrictive covenants.
Yeah, and I'm just going to show you actually, because as an additional section, we have some customers who like to just do their own, whatever is specific to their industry, and you can certainly, it's just coming to my head, and I probably wouldn't put dress code in a contract, to be honest, but you can type in a heading, and again here you've got free text, and you can see you've got basically, you've got these kind of word formatting that you can use as well. I'm not going to, I'll just save them. But Jenny mentioned the templates that we have. If you see this little view sample additional content tab here, if I click on that, it's going to bring me into our website. Now it's locked down because we lock it down for non-customers. I have a license key, but I just don't have it to hand at the moment. I'll bring you in separately and sorry, bear with us. Perfect, I'm in now. So this is our website, and there's a huge amount of support on the website as well. And I'm not forgetting out of it again. Perfect, there's my license key. And while we're here, I'm just going to show you, I've kind of gone off and I wanted to stick with the contracts, but I just want to show you the HR guidance. Got a huge amount of HR guidance on record keeping, managing sick leave, sample interview questions. So here there's a whole load of questions on what are useful interview questions, what you should, interview guidelines, what you should and should not do when you're having an interview. We have guidance on retirement age, rest breaks. I want to show you the template HR documents here as well. Again, just day-to-day forms that will help you manage your HR issues, I suppose. Now, the additional contract clause, I've gone around it a long way, but here I am at it. These are all the sample extra clauses that you might want to include in your contract. So we talk about car allowance, Sunday premium, right to search, layoff short term. I just click on that one, so it's quite a short clause, but it's a powerful clause as well. And literally, I just copy and paste that, and I bring it into my Bright Contracts program.
And anything you do copy and paste, using those additional content fields, you can adjust and you can edit yourself. Obviously we've done it there, kind of covering the legislative requirements. But as Laura said, you can create your own, or if you want to use the templates that are there, adjust them to suit your own requirements.
Yeah, perfect. So that's done. I brought that in. My contract is done. I'm going to hit save, and I just want to show you now. Go up the top here, and I can hit preview. And here is my contract of employment that is fully compliant with my Irish legislation. It has all the pieces of legislation that I need and additional pieces that are going to protect my business. So you're fully compliant. It's 6 pages long, which is really nice, concise. You don't want too many additional clauses.
You wanted to show them the sick pay.
Yeah, I'm gonna kind of go through it. Just no, you're fine. So this is my induction. It gives me kind of again a general overview. My probation period, because I clicked it, it was just one little click box that I ticked, and now I've got a nice conclusive probationary period, which helps me manage my new starter. My place of work, my rest breaks are in there. What was the other one we said?
The sick pay, wasn't
it? Even holiday as well. It's very small on the software, but then it's a really conclusive clause here, and it talks about what happens if an employee leaves employment and they've taken more holidays than they've accrued, or they haven't taken all the holidays that they've accrued up to that point in the year,
and what their entitlements are. Even if you don't kind of specify how many days or what the calculation method is, the little kind of blurb there on holiday pay gives you the Working Time Act and specification of what their entitlements are, regardless of what you specify.
Yeah, and then we move on to attendance and sick pay, and although we tick the box to say there was no sick pay, we have the policy here saying that they may be entitled to their social welfare benefits. So again, we're compliant with everything we need to be there. And we've got our retirement age, we've got our termination clause. We've got our lovely dress code policy, with notification, and we've got our governing law because it's under the laws of Ireland. So it's very nice and concise, and that is your contract of employment created. Just to X out of that, up the top here now I can go into headers and footers, and I can change the fonts and the styles if I want to make those changes that are in line with what I do in my company. So to use it then, I just print that off, or I can export it to a PDF and save it elsewhere. So that's really my contract really quickly. Once I give it to the employee, I can mark it as signed here as well and say that's signed, okay. And then it tells me now that
the handy feature as well of marking it as signed means you can't go in and make adjustments without marking it as unsigned. So if you were just going in and just checking something out and happen to kind of mistakenly put in that they were due 40 days holidays instead of 20, it's not easy. You can't do that. You'd have to make a concise decision to actually do that, because once you sign it, it's kind of locked down until you unsign it again.
But I can make unlimited contracts for any employee. Now I could go in and say, well actually Robert is now here 2 years and he's got a pay rise and his hours have changed, and I can create a new contract for Robert, and that's fine. I'll just have another date here. So as things change, you can add more contracts as well. I just want to move on to the handbook, because again, we touched on those 30 pieces of legislation and having guidance for you as an employer. And you know, I think that the handbook is really important, as it sets out for both employers and employees what's expected, what's the lay of the land, if you like, for in this company, how we do things. To start off, we've got fully inclusive disciplinary, grievance and bullying and harassment policies. So they're all there. So all our policies are actually listed here along the left hand side. If I click into any of them, with my disciplinary procedures, and you see the text just appears here. The beauty with the handbook, I suppose, if you like, is that it's really flexible to change, because the handbook is not the legal document. The legal document is the contract. So with the handbook, you've got full flexibility to make any changes to the context or to the clauses that we have here. To make a change, you would simply go over to the right-hand side here. We have an edit this section. Are you sure? Yes, I am. And now you can see again, it kind of opens up in this Word format where I have these options at the top, and I can make changes. I'm just going to revert back. I just wanted to show you as well the equality policy, because we talked about that, about, you know, as an employer, just making yourself aware of a couple of things that will help you run your business smoothly and compliantly. Like, this is a really good one, and just even if you were to read over to say, well, what do we need to be aware of as an employer? And it talks about equality in your recruitment and selection, in your career development, and complaints, bullying and harassment. So as much as a guide for employees, I think this is a really useful tool for employers as well when we talk about equality. So we scroll down then, continuing on, and we get into the terms and conditions. And I would imagine this is where, well, it is where a lot of our customers make changes. We talk about probation policy, hours of work. Now these are separate to the contract clauses, but they just might go into a little bit more detail. Like the social media policy, massive at the moment. What can people say? Should they be posting on social media? And that's a full policy there. Again, dress code, we already talked about it, and again, obviously I can make any changes I want here. So we really made this handbook fully inclusive. It's ready to go if you like, but we do have again some optional sections up the top.
And these are just kind of suggested optional sections, you know, the likes of your performance management. If you've got CCTV, you need to make sure you have a policy on that. And if you record telephone calls for, you know, training or recruitment purposes, again, you need to have a policy on that. You know, so we have sample contents there which you can use. I just want to say point, because we talked about retirement a lot today, we have a sample retirement policy where we give some suggested wording as to give you that objective justification for having your retirement. So I can preview it here and I can see our sample retirement clause. Okay, I'm happy with that. I want to include it in my handbook. I'm just going to tick it and I'm going to say, okay, put that in. My retirement clause is now going to show down here at the bottom. And it's there, and now I said we've given some sample things, but obviously retirement is really going to be specific to your company, so this is one where I'd definitely recommend that you go in and you make some changes and tailor it to your organisation. So there are extra clauses in there as well.
really, again, you can get to tailor it, you can reorder it, you can print one particular section. If you're doing a disciplinary procedure with somebody, you don't want to print off the whole document because it is quite a lengthy document. You can just print off that one section as well. And we have a signature page if you wanted to get people's signature to say they've agreed it as well. And it goes on to leaving benefits and pension. So I'll just hit preview, just again, very quickly so you can see it.
Just some key considerations there whilst you're looking at the preview of it, Laura. The handbook should be easy to read and understandable for employees. It's not a place for jargon or legal blurb. It should be easily accessible to all. So all employees should receive access to it, or all employees should receive access to it, whether it be in a soft copy or you leave a hard copy in the canteen. People can view it as they need to.
There's no need to print it off, or you print off the contracts definitely, but as you can see, it's a lengthy enough document. You don't have to print it off for every employee once it's accessible.
Well, that's it. And if you do make changes to the handbook, you can just inform the employees that a change has been made to the retirement policy in the terms and conditions of your handbook, and kind of point them in that direction. So then you're informing them of the change. But as Laura said, you don't need to actually give them a physical copy of it. You're just making them aware that you've made that change, and they can view it at their own discretion then. Let me see. You should ensure that really kind of any new starters read it and understand the handbook, and it would be advisable to get a signature to that effect. So you could, send a soft copy, but maybe print out a signature page that all employees can sign, or you can have individuals sign it. That's an option within the software there as well. And again, as Laura said, the contract is what is applicable to the individual. You make a change to the contract, the employee has to agree to it. They have to sign it. You're under no obligation to kind of let employees know what you're changing. Sorry, not what you're changing, but you can make changes to the handbook a lot easier. And they're obviously privy to your company and what's, kind of applicable to your own company's requirements, so they can be adjusted.
Yeah. I suppose then just kind of one other thing then on the by contract software, which is kind of a key point for a lot of our customers, is that should the legislation change or any part of employment legislation change, we make the changes for you and we notify you. A really good example, well, we've had two of them actually today, is the paternity leave and retirement. So paternity leave was new legislation in Ireland last September. So a lot of employers are thinking, right, well, how does that apply for me? I really need to get a procedure in place so that when the question arrives on my desk, I know how to deal with it. What we do is we write that policy up and we just send it through the software automatically to you. So what will happen is when you log into your by contract software, you'll get a little yellow highlight bar notifying you that there's an update there. You can click in to see a little bit more information. Oh yeah, that's the paternity leave, I really want that in, and you just click it and it's now part of your handbook and you can just roll that out. So it really means you don't have to worry about, oh well, how does that change affect me? We do all the worrying and we'll just put it across, we'll make it available to you then as well. So that's a key point. I see that there's more questions coming in, so I think we'll pop back to questions. Is that okay with you? We'll take a few minutes for some more questions, which is great to see. Bear with me now, so I just open this up. Hopefully have I covered all the main points on the contract?
I think so, absolutely, yeah, definitely.
Bear with me, okay, we're just trying to pick back up where we were. Can we have a copy of the slides? Yeah, we are recording them and we'll be sending them on to you. Yeah, I'm sorry, we're just reading them as we go. There's quite a lot. We're not going to get through all these. We will come back to you if we don't. Should our contracts include employee pension options? I'm going to start off with a yes. Yes, you do need to make reference to pension in your contract, and you do. Even if you didn't have a company pension scheme, you need to make reference to the fact that employees can access a PRSA, which is a legal requirement, and our contracts will include that for you. However, if you do have a company pension scheme in place, my advice would be, yes, make reference to it in your contract, but don't go into too much detail on it. For example, it would be sufficient to say there is a company pension scheme in place. Contact your manager for more information. Because let's say you're paying in percentages, you're doing 5% and 5% contributions. If at any point you wanted to change that, it's very tied down. It's contractually agreed if it's in the contract. Just to make it a bit more flexible for you, just not to put too much information in. Do you have to pay a premium wage for Sunday workers, and is an increase of 1 cent enough to satisfy legal requirements? Yes, you do need to pay a premium wage for Sunday workers. This is actually a topic we recently just put up a blog on our website on. I'm going to try and get into it there, Jenny, if you want to take on some of that. I don't know if a 1 cent increase would be justified as sufficient.
I don't think so, no. I mean, again, like if it was brought, to a head, it has to be seen to be a premium rate.
Yeah.
So, it has to be over and above what you would normally pay them. I don't think if you had an adjudication officer out or an inspector that they would class a 1 cent increase as being premium.
Yeah.
So really, kind of common sense would prevail on that one.
And just going to refer that to on our blog here on the website, we do keep it up to date with kind of information as it comes. But only recently, 15th February, we did a Sunday working one, and there's actually a case on it. I'll just touch on it really quickly, because there was a hotel and they said the premium for working a Sunday was to get your Sunday carvery meal included, and the judge found that wasn't, it had to be an amount, it wasn't sufficient to pay a meal. I would question whether a cent would be acceptable.
Yeah, no, I can't imagine that a judge would see that as being acceptable, no.
Right, what is now? We just move on now. Is it acceptable to put in the contract that the employee's job description is as in the handbook? You can do. Generally in the contract, I would advise not to put a full job description, because a full job description can be quite lengthy as well, and what we recommend is certainly to make reference to it, and you have to make reference to the job description and what's involved in the jobs, and usually I would say it's as part of the appendix, or you have it attached to another document. Kind never come across, to be honest, that the job descriptions are in the handbook.
The company handbook is generally kind of kept to your policies and procedures.
I don't know if it's wrong. If you're happy and you think everybody will be happy to viewing everybody's job description. The thing is, the job descriptions can, in my experience again, which can vary, it can change. A role can change from 1 week to the next. So if you're putting it in your handbook, it's making it a lot harder to change it as well. Just in terms of having to roll that out.
I think as Laura said, you might be better just keeping it as a separate document.
It's fine as a separate document, as an appendix. To have that as a file. Yeah.
Well, how do you inform your employees that you've updated a few clauses in the handbook? Again, that can be just a quick email, and just say that if they have access to the handbook, you can just send them a quick email and just say that you've made amendments to whatever clauses that you've adjusted in the handbook, and that you request, in their own time, that the employees take a look and ensure that they understand it. And leave it open then, that if they have any questions, that you're available to be asked those questions as well.
I think I'm conscious of time as well. We've definitely ran over, but there's a few questions I know that we didn't get to, but it's just they're coming in so fast, so we'll go back to everybody that we didn't get to. I hope you have found it informative and useful. Just to, I suppose, remind everybody again that we are offering the 15% off this month for people who attended today's webinar, and we'll send a link to that with the slide and the recording at the end of after later on today. And if there are any other questions, please feel free to reply and let us know. And again, just another reminder that we have our next webinar on the 30th of March as well. So I think we'll sign off with that. Thank you all very much for attending. I hope you found it useful, and hopefully we will hear from you all soon.
Thanks, guys.